The morning of April 9th, 1886, a woman stood alone in a county courtroom in Halcyon, Colorado, and read aloud from a water statute she had copied by hand onto 7 sheets of foolscap the previous winter. The room was not large. The ceiling was low pine board, the kind that swelled in summer and shrank again every fall, leaving fine seams of daylight visible at certain hours. A stove near the back wall gave off a thin, unsteady warmth, and the smell of pine wood smoke and the older smell of tobacco the bailiff had given up the year before sat together in the corners of the room. Judge Orrin Farwell sat with his hands folded on the bench and listened without expression, the way a man listens when he is trying to decide whether he is being surprised. Across the aisle, 2 lawyers from Denver had arranged themselves with the easy confidence of men who expected to be done before noon. The sheep rancher from the South Fork of Antler Creek spoke for 40 minutes without notes, without interruption, and without raising her voice above the level of ordinary conversation. What most people in that valley expected was a short proceeding and a long humiliation. They had been calling her work Voss's Sheep Court for more than a year by then, a label that had traveled from the Halcyon trading post to the church steps to the supper tables of every cattle outfit in the county. The name was meant to be funny. It was meant to settle a question that the speaker believed required no settling. And when Judge Farwell's ruling reached the valley 2 weeks after that morning, the people who had used the name discovered that the question had been settled, though not in the direction they had assumed. This is the story of how Nora Voss got there. She had come to the 340-acre Voss Ranch on the South Fork of Antler Creek in the spring of 1884, not by choice so much as by the particular arithmetic of grief. The ranch sat low against a long bench of bunch grass and sage, the creek cutting south of the cabin in a slow run of cottonwood and willow that turned the air green in May and the color of old leather by August. The house was a single-story log structure with a sod roof. Martin had repacked the autumn before he died, and the wind off the bench moved through the eaves with the steady hush a man learns to stop hearing after a winter or two. Her husband, Martin Voss, had died of fever in early March of that year, 10 days before the first thaw, leaving Nora at 31 years old with a flock of 190 sheep, a property encumbered by a modest note to the Halcyon Land Office, and a younger sister named Agnes who had been living with them since the previous autumn and who now had no particular reason to leave. The 2 women inventoried what remained. The sheep were healthy. The ditch running from the main channel of Antler Creek to the near pastures was in fair repair. The south fence needed new posts in 3 places. They could manage, Nora decided. She told Agnes this plainly, on the morning after Martin's burial, standing in the yard with the creek audible beyond the cottonwoods. Agnes looked at the flock in the near pasture and said nothing, which Nora understood as agreement. What Nora did not yet know was that the Consolidated Cattle Company had filed a water use claim on Antler Creek in January of 1884, 2 months before Martin died, and had begun construction of an upstream diversion dam in June. By July, the flow in the South Fork had dropped by something close to 2/3. Nora noticed it first in the ditch. The level fell 6 inches in a week, then another 4 by mid-month. The near pasture stayed green on what remained, but the lower 40 acres browned and crackled underfoot by August, and 16 ewes that normally grazed there lost condition through the summer in a way that showed plainly in the fall wool count. She rode upstream on a Wednesday in late August to see for herself. The bay mare she rode was a steady, square-built animal Martin had bought from a freighter in Pueblo, and the saddle was a worn double rig, with the leather gone soft along the latigo, smelling of horse sweat and the neat's foot oil she rubbed in once a month. The trail along the South Fork rose slowly through cured grass and over flats of sun-cracked clay. and the August heat lay on the bench in a flat, dry weight that pulled the moisture from a person's mouth. Before they noticed, it was gone. Beckett's Dam was a substantial earthen works, maybe 40 feet wide at the crest and braced with timber on the downstream face. The new channel it fed ran northeast toward Consolidated's upper pastures. A company hand was there repairing a section of the brace, and he watched Nora without speaking as she sat her horse and studied the structure. She looked at the dam for a long time. Then she turned and rode back downstream. She did not go to see Harlan Beckett. She had met him twice, once at a Cattlemen's Association gathering in Halcyon 2 years earlier, and once when he had ridden the South Fork boundary with Martin to discuss a fence line question. Beckett was a composed man in his middle 40s, with a way of speaking that made his preferences sound like conclusions already reached. He had been hired from a firm in Denver to manage Consolidated's Valley operations, and he carried that employment like a title. He was not cruel exactly, but he was the sort of man who had rarely been told that something he wanted was unavailable. Nora's father had worked irrigation in the Uncompahgre Valley before he died, and she had watched him as a girl lay out field channels by eye and by level, reading the slope of ground the way others read a page. She had absorbed from him a practical understanding of where water went and why, and more usefully, a sense of when a channel was being asked to do more than it could. She spent 3 weeks in September studying the lay of her property below the main ditch, walking the lower pastures in the early morning when the ground held its moisture longest, dragging a pointed stick along possible grades. By mid-September, she had a route. It ran 380 feet from a point on the South Fork above the intake of Beckett's influence, angled southwest along a natural swale, and terminated in a collecting basin she dug herself in the corner of the lower 40 acres. Clem, her border collie, followed her through every day of the digging. He was 4 years old and had the collie habit of positioning himself wherever he judged most useful, which during the ditch work meant just behind Nora's left heel, where he could watch both the work and the horizon simultaneously. Nora dug the trench mostly alone, though Agnes spelled her on 2 of the longer days. She worked with a long-handled spade Martin had shod with iron strap the previous winter, and her hands wore through a pair of cotton gloves in the first 3 days, and a second pair before the trench was halfway. The October ground at that elevation came up in clods that smelled of root and old grass, and the wind off the bench dried her sweat before it could soak the wool of her shirt. By mid-afternoon, her shoulders ached in the steady, manageable way that hard ground produces in a person who has known hard ground before. The work took 11 days, spread across 3 weeks, finished in late October before the first hard frost. When she opened the upper end of the new channel and watched the water find its way along the grade and collect in the basin at the lower end, she felt a satisfaction she did not describe to anyone. It was enough that the water moved. Dolph Crane saw the ditch in early November. Crane was Beckett's foreman, a broad-faced man who came south of town when he needed to, and who had a habit of delivering his opinions at full volume regardless of setting. He was at the Halcyon trading post on a Friday morning when 2 of Nora's neighbors, Ed Halloran and the younger Birch boy, mentioned that the Voss woman had dug herself a new water channel. Crane set down his coffee cup and said that a sheep rancher fighting a cattle company's waterworks with a shovel was the funniest legal strategy he had heard of, and that she might as well hold court down there in her sheep pasture, for all the good it would do her. Someone called it Voss's Sheep Court. Crane liked the name. He used it himself on the way home, and twice more before December. The name reached Nora through Agnes, who had heard it from the postmistress on a trip into Halcyon in December. Agnes brought it home carefully, the way she brought most difficult things, approaching the subject sideways over supper. She said she had heard people talking in town, She said the consolidated outfit seemed to think Nora's situation was amusing. She said the words sheep court with a particular flatness, as though she could make them smaller by draining the sound out. Nora listened to this. She was quiet for a moment, cutting a piece of salt pork on her plate. Then she said, "Let them." It wasn't defiance exactly. It was closer to the remark of someone who has already moved on to the next calculation. Because what Nora had decided, in the weeks between finishing the ditch and the arrival of Consolidated's first formal letter, was that a shovel was not enough and had never been enough. The ditch protected the lower pastures for one season. Beckett would be upstream next summer and the summer after that. The water question had to be settled in the language where such questions were settled, and Nora understood that language was legal before it was physical. She rode to the county land office in January of 1885 and asked for access to the state water statutes. The road into Halcyon ran 9 miles north through frozen ruts and patches of crusted snow that broke under the mare's hooves with the small, sharp sound of glass cracking. The cold worked up through the leather of her boots and into the iron of the stirrups, and by the time she tied off at the rail outside the courthouse, her fingers were numb to the second knuckle, and her eyes watered against the wind off the open country. The clerk, a younger man named Alfred, who seemed uncertain what to make of her, produced 2 bound volumes of Colorado's 1876 Water Code and set them on the counter. She spent 4 hours there that day, reading slowly, and when the light in the office got too thin, she asked Alfred whether she could copy the relevant sections by hand. He said he supposed she could. She brought her own paper the following week and copied 11 pages of statute by lamplight in the office, and then by the lamp at her kitchen table through February and March. The kerosene lamp on the kitchen table was a brass-bodied affair with a smoke chimney that wanted cleaning every other night, and the small flat circle of yellow light it gave off was the precise size of a saucer. She copied in a slow, even hand, dipping the pen carefully so as not to blot, and the only sound in the cabin past 9 o'clock was the soft tick of the stove cooling down and Clem's ribs rising and falling against her foot under the table. She was particularly interested in the doctrine of prior appropriation, which the Colorado Code had established at statehood. The first person to put water to beneficial use on a given stream held the superior right, and subsequent diversions could not diminish that prior use without the prior user's consent or a court ruling. The Voss Ranch had used Antler Creek water since 1878. Consolidated's diversion dated from the spring of 1884. The sequence was plain. Beckett's formal demand letter arrived in April of 1885. It was written on Denver firm letterhead and instructed Nora to cease her unauthorized secondary diversion, which the letter characterized as a trespass on the water rights held by Consolidated under its 1884 filing. The letter was 3 pages long and included 3 numbered citations to the same paragraph of the Water Code, which Nora recognized as a repetition rather than an argument. She set the letter on the kitchen table and read it twice. Agnes read it after her and set it down with her hands flat on the paper. "They have lawyers," Agnes said. "We have $400 and a flock of sheep." "We have something they don't," Nora said. Agnes waited. "We were here first," Nora said. Agnes did not look convinced. She was 26 years old and had watched the 2 of them carry the ranch through a difficult first year, and she knew what a legal proceeding cost before it cost the ruling. She said quietly that she thought Nora should at least speak to someone in Halcyon who knew something about water law. She said Martin would have wanted her to be careful. She said the words without cruelty, but the weight behind them was real. Nora did not argue with that. She said she would think on it. What she was already thinking was that the lawyers she could afford would know less about the Colorado Water Code than she now did. having spent the better part of 3 months with nothing else. The summer of 1885 was a wet year in the valley. The snowpack in the mountains above Antler Creek was heavier than it had been in 6 years, and the May melt ran fast and high. Consolidated's upstream dam held through May but showed stress along the bracework by early June, and a company crew worked the site twice in the first 2 weeks of the month, trying to reinforce the downstream face. Nora rode up to observe the condition of the creek on June 10th and noted the spillway was running nearly full. She came home and cleared the mouth of her secondary ditch of the winter debris she had left in place during the dry months. On June 14th, 1885, the upstream dam failed. It went sometime before dawn, the earthen crest washing out along a 20-foot section where the timber bracing had been insufficiently set. The creek ran at nearly 3 times its normal June level for most of that day, carrying with it part of the dam structure and a quantity of rock and debris from the drainage above. By mid-morning, it had overflowed the main channel banks in 3 places along the South Fork. Ed Halloran's lower pastures flooded to the fence posts. 2 of the Birch family's outbuildings along the creek sat in 2 feet of moving water by noon. 3 ranches along the North Fork reported fence damage and lost hay stores. Nora's secondary ditch caught the overflow before it reached her lower 40 acres. The channel she had dug the previous October ran full for 6 hours. The collecting basin at the far end filled and slow spread across a 1/4 acre of rocky ground, well clear of her pasture. Her lower 40 stayed largely dry. The near pastures flooded briefly along the eastern edge, but the sheep had been moved to higher ground at first light, and the flock came through the day without loss. She walked the ditch that evening with Clem at her heel, checking the channel walls for damage. The June light at that hour came in long and amber across the bench and lit the willows along the South Fork in pale gold, and the air smelled of wet sage and turned earth, and the clean cold that comes off snowmelt water late in the day. The soil had held. The grade she had calculated held. At the far end, where the basin had spread across the rocky ground, the water was already receding in the long June light. She stood at the basin's edge for a while and looked back up the 380-foot length of the ditch toward the creek. Agnes met her at the yard gate when she returned. "How bad is it?" she said. "Lower 40 is dry," Nora said. Agnes was quiet a moment, taking that in. "The Hallorans lost their lower pasture," she said. "I heard. Birches lost a shed." Nora nodded and walked past her toward the house, Clem falling in behind. She was already thinking about the petition. The shift in the valley's view of the situation happened over the rest of that summer, without announcement and without anyone being required to state openly that they had been mistaken. The flood had done a thing that argument could not. It had demonstrated in plain terms whose understanding of Antler Creek's water behavior had been correct. Beckett's upstream works had failed under conditions a more careful reading of the creek's history would have anticipated. Nora's ditch, which Dolph Crane had described as a sheep rancher's attempt at legal strategy, had done precisely the physical work it was designed to do. Ed Halloran said as much to the postmistress, who told Agnes, who told Nora. Nora received this information without comment. Beckett himself rode out to the South Fork in late July to look at the dam site and, by his account, to assess water conditions downstream. He sat his horse at the edge of Nora's lower pasture for a while, looking at the dry ground and the intact fence line, and the sheep grazing quietly in the recovered grass. His face did not show whatever he was thinking. He rode away without stopping at the house. Dolph Crane used the phrase Voss's sheep court one more time that summer in the yard of the Halcyon stable, talking to 2 consolidated hands about the petition Nora had filed in September. This time the men he was talking to were quieter than he expected. The phrase sat in the air between them without the laughter it had carried the winter before. Crane picked up his horse's reins and said something about lawyers and court fees that nobody remembered afterward. Nora filed her water petition with the county court in September of 1885. The filing fee was $4, which she paid from the household account. The petition cited the prior appropriation doctrine by the specific section numbers she had copied from the statute, named Consolidated Cattle Company as the respondent, and described in detail the 1878 date of the Voss Ranch's first beneficial use of Antler Creek water. It attached a hand-drawn diagram of both the main ditch and the secondary channel, with their relative positions to the diversion dam site, and it referenced the June 14th flood as evidence of the structural and hydrological consequences of upstream interference with a natural stream course. The petition was written in Nora's hand, which was plain and even across the page, and it was organized with a clarity that Judge Farwell's clerk noted privately was superior to several of the commercial filings he processed that quarter. Whether that observation reached the judge before the hearing date, Farwell never said. Consolidated retained 2 lawyers from a Denver firm, a senior man named Pruitt and a younger associate whose name the record does not preserve clearly. They filed their response in January of 1886, arguing that Consolidated's 1884 filing superseded the Voss Ranch's informal historical use under the provisions of the newer codified filing system, and that the 1878 use had never been formally documented and therefore could not anchor a prior appropriation claim. The response was 12 pages long and cited 8 separate cases from other jurisdictions. Nora read the response at the kitchen table over 2 evenings. She found the 8 case citations and looked up 4 of them in the county land office volumes the following week. 2 of the cited cases supported Consolidated's position as stated. One was a federal circuit matter that did not apply to Colorado state water law at all. One, a Wyoming case from 1881, actually supported the informal use standard Nora was arguing. She made a note of it. She added it to her own filing documents. She sat with the stack of papers at the kitchen table that evening, and Agnes sat across from her, and for the first time since the legal proceeding had begun, Agnes was not looking at the papers with doubt. She was looking at them with something closer to attention. She had spent the previous December copying 2 more sections of the water statute at Nora's request, and she had begun to understand the structure of the argument her sister was building. She did not say anything that evening, neither did Nora. They worked in the lamp's quiet circle until the oil ran low. Before the story moves to the hearing, this is a good moment to ask you something. If this kind of story holds your attention, consider subscribing so you don't miss the next one. Now, back to Halcyon, Colorado, in March of 1886. The hearing was set for March 17, 1886. Nora rode to Halcyon the evening before and stayed the night at the boarding house run by a woman named Garland on the north end of town. The road that day held a thin glaze of late winter ice in the shaded sections under the cottonwoods, and the mare picked her way across the slick patches with the careful, deliberate placement of an animal that had learned the country a long time ago. The wind came down off the divide in cold, steady pulses, and Nora kept her wool collar turned and her hat brim pulled low, the oilcloth packet of her papers tucked inside her coat against her ribs, where the warmth of her body would keep the ink from blotting in the damp. Agnes stayed at the ranch with the flock. Nora brought her 7 pages of copied statute, her annotated case references, her petition document, and the hand-drawn creek map, all wrapped in a piece of oilcloth against the weather. She ate supper alone in the boarding house's common room, reviewed her notes until the lamp in her room began to sputter, and went to sleep. She was in the courtroom at 8 in the morning. Pruitt and his associate arrived at 8:30 with a document case, and a manner that suggested they found the setting somewhat beneath them. Pruitt looked at Nora, standing at her table with her oilcloth packet open and her papers arranged, and said something to his associate in a tone low enough that the words did not carry. His associate permitted himself a small smile. Judge Farwell entered at 9 o'clock and called the proceeding to order. Pruitt opened for Consolidated. He was practiced and fluent, and he laid out the codified filing argument in orderly sequence, emphasizing the 1884 documentation date and the informal and undocumented nature of the Voss Ranch's historical use. He spoke for 22 minutes. He cited his 8 cases, including the Wyoming case. When he sat down, he appeared satisfied. Judge Farwell looked at Nora. "Ma'am," he said. Nora stood. She picked up her first sheet of notes. She said she intended to show 3 things: that the Voss Ranch had put Antler Creek water to beneficial use continuously since 1878, predating Consolidated's diversion by 6 years, that the Colorado Water Statute of 1876 did not require formal documentation for prior appropriation rights to attach, but required only evidence of actual beneficial use, and that the Wyoming case counsel for the respondent had cited in support of their position, in fact, contradicted it, as the Wyoming court had ruled in that matter that informal historical use was sufficient to establish priority. Pruitt shifted in his seat. She laid out the beneficial use evidence first. She had a dated bill of sale for sheep from a ranch in the Uncompahgre Valley in 1878, which indicated the Voss operation had been running livestock on the South Fork pastures in that year. She had a land office notation, retrieved from county records, confirming the ditch running from Antler Creek to the near pastures had been constructed and in use as of 1879. She placed both documents on the bench for Farwell's examination. She read the precise language of the prior appropriation section of the Colorado Code. She read it slowly and without inflection, the way she had read it to herself 100 times in the lamp circle through the past winter. The section was plain. The first person to apply water to beneficial use on a watercourse held the prior right. No formal filing was required for rights established before 1876. Rights established after statehood required filing, which the Voss Ranch had not done, but which Nora argued was remedied by the current petition. The first opportunity to formalize what the ranch's use had already established as a matter of fact. She turned to the Wyoming case last. She read the citation Pruitt had used, then read the passage he had not quoted, which stated that the Wyoming court had declined to void a prior informal use on the grounds that beneficial use, once established and maintained, survived subsequent changes to filing requirements. She looked at Pruitt while she read this. He was looking at his papers. "The court in that matter," Nora said, "found for the prior user, as we are asking this court to do today." Farwell asked 3 questions. 2 were clarifying points about dates, and 1 concerned the secondary ditch. Nora answered all 3 in single, precise sentences. Farwell made notes on his pad. He said he would take the matter under advisement and issue a written ruling. The proceeding was finished before noon. Pruitt gathered his documents without looking at Nora. His associate was already at the door. Dolph Crane, who had ridden in from the Consolidated camp to attend the hearing on Beckett's instruction, was seated in the back row, and when Nora walked past him toward the exit, he did not meet her eyes. He had been in that courtroom for 40 minutes and had watched a woman who ran sheep on 340 acres of Colorado bottomland dismantle a filing strategy prepared by a Denver law firm using a sheet of notes she had written herself and a borrowed Wyoming case citation she had apparently found herself. He was quiet all the way back to the Consolidated camp, and the men who rode with him noted later that he did not say much that evening. The ruling came on April 9, 1886. Judge Farwell's written decision was 4 pages. It found that the Voss Ranch had established beneficial use of Antler Creek water in 1878 and had maintained that use continuously and without abandonment through the period in question. It found that the Colorado prior appropriation doctrine attached to that use and was not voided by the ranch's failure to file a formal claim prior to the current petition. It found that Consolidated Cattle Company's 1884 diversion was a junior water right to the Voss Ranch's senior right, and that Consolidated was therefore enjoined from diverting water in quantities that diminished the Voss Ranch's historical flow below its 1878 level. The secondary ditch, Farwell noted in a single paragraph near the end, was a lawful exercise of the petitioner's rights as a senior water user. Nora received the ruling at the land office counter, delivered by the court clerk in a plain envelope. She read it standing at the counter. Alfred, the clerk who had produced the statute volumes for her 14 months earlier, was watching from behind his desk with an expression she chose not to examine too closely. She folded the ruling back into the envelope, tucked it into her coat, and went to find her horse. She rode home through the afternoon. The creek ran clear and steady alongside the road for most of the last 4 miles. The high water of the spring melt still a few weeks off, the surface broken in places by the dark rounds of stones the freshet would soon submerge. The willows along the South Fork were showing their first pale green of the season, and a pair of meadowlarks called from the bench grass with the long falling whistle that meant the deep cold was finally breaking. The mare's breath came out in slow plumes that thinned and disappeared into the afternoon air, and the leather of the saddle had warmed under Nora's weight to the soft, lived-in temperature that always made the last hour of a long ride the easiest. She turned into the ranch yard as the light was going amber, and Agnes was at the gate before Nora had fully stopped, reading the answer in her sister's face. "We won?" Agnes said. "We won," Nora said. Agnes put both hands over her mouth. For a moment she stood like that, and then she laughed, a short, slightly disbelieving sound, and went to take the horse's reins. Clem came out of the yard at a trot and circled once around Nora's boots as she dismounted, the way he always did when she had been gone a full day. Beckett received a copy of the ruling through his Denver lawyers, who wrote him a 2-paragraph summary letter that arrived the same week. The letter reached him on a Tuesday afternoon at the Consolidated headquarters, a long timber frame building with a tin roof and a porch that ran the length of the south side, and he read it standing at the open door with his hat still on, and the smell of horse and hot dust coming up off the corral behind him. He came out to the South Fork personally the following Saturday. He rode into the yard and dismounted and knocked at the door, which was the first time he had done any of those 3 things in the 2 years the water dispute had run. Agnes answered the door and went to find Nora, who was at the near pasture checking a fence repair. Beckett waited in the yard. Clem sat at the porch step and regarded him without hostility and without welcome, in the precise neutral posture of a dog that has been told nothing yet about this person. Nora came around the corner of the house and stopped at a distance of about 10 feet. Beckett held his hat in his hands. He was a composed man, and he remained so, though his composure had a different quality than it had carried before. He said, "I wanted to come and say you argued it well." He paused. "Better than my people expected." Nora looked at him a moment. "The law was on our side," she said. "I just found it." Beckett nodded once. He put his hat back on. "I'll be adjusting the diversion works," he said. "You should see a full flow by June." "We'll check it," Nora said. He mounted and rode north along the South Fork Road. Nora watched him go until the dust settled back onto the road, then turned and walked back toward the near pasture. The fence repair still needed 2 more posts. The ruling moved through the valley faster than most legal decisions did, partly because the flood had already prepared the ground, and partly because the terms of the decision were plain enough that anyone who read it could understand what had happened. Farwell's 4 pages established, in the language of the county record, what the community had been watching informally for 2 years: that the woman on the South Fork had understood both her water and her law better than the company that had tried to take the first and dismissed the second. Ed Halloran read the ruling and came to see Nora in May with a question about his own water rights on the North Branch. He had a 1880 first use date on file and wanted to know if it was worth anything. Nora showed him her petition, described what she had done and in what order, and told him to go look at the county land office volumes himself. He came back a month later with his own hand-copied notes and a set of questions she spent an afternoon answering. By September of 1886, 3 other small ranchers in the valley had filed their own prior appropriation petitions using the same statutory language Nora had cited. 2 of those petitions succeeded before year's end. Dolph Crane left Consolidated's employ the following year, for reasons that had more to do with his temper than with the water ruling, though the 2 things were not entirely unrelated. He moved north to a ranch operation in Larimer County and was not a presence in Halcyon afterward. People there stopped using the phrase Voss's Sheep Court, not through any decree, but simply because the phrase had stopped meaning what it was intended to mean. The name Farwell used in the ruling was the prior appropriation claim of the Voss South Fork operation, and that was the name that attached to the case in the county record, where it was cited twice in the following decade by other petitioners arguing the informal use standard. Agnes stayed on the ranch. She had come to help her sister through a difficult season and had stayed for what turned out to be a different kind of season entirely. And by the time the water ruling was issued, she had stopped thinking of herself as a visitor. She had copied statutes by lamplight through 2 windows. She knew the prior appropriation doctrine well enough to explain it to a neighbor's wife, who asked about it the following spring, which she did, patiently and in plain terms, at the Halcyon Church social in June of 1886. The 340 acres of the Voss Ranch did not grow larger in the years after the ruling, but it did not shrink either. The flock held above 190 head most years and climbed past 220 by the early 1890s. The secondary ditch Nora had dug in the fall of 1884 became a permanent feature of the property's water management, maintained and regraded twice in the decade after the ruling, and eventually lined in part with flat stone that Agnes sourced from the creek bank. A neighbor's boy who helped with the relining in 1893 asked Nora who had designed the original grade, and she told him her father had taught her to read a slope. The boy nodded as though this explained something he had already suspected. Nora Voss argued no other court cases. She did not need to. The one she had argued settled the question for the South Fork, and the ripple of the ruling settled it more broadly across the valley in the years following. What she had done in Judge Farwell's courtroom on March 17, 1886, was not a speech or a performance. It was the application of a specific body of knowledge to a specific problem, patiently assembled over 14 months from the volumes of a county land office, organized plainly on 7 sheets of foolscap, and presented in a voice that did not vary from ordinary conversation, because there was no reason it should. She kept those 7 sheets in the oilcloth packet for the rest of her life, not as a trophy, more the way a carpenter keeps a plumb bob that has served him well, a thing that did its work and has earned its retirement in a place where it can be found. Patience, in the end, is not a temperament. It is a kind of labor, accumulating toward something the impatient cannot see from where they stand. Nora died on that land in the winter of 1911, 25 years after the ruling. Agnes was with her. The flock was down to a smaller number by then, leased in part to a neighboring family, and the ranch had weathered several dry years in the early decade, with the water rights intact and the ditch running. What Halcyon remembered of her in the generation that followed was not the grief of 1884 or the harder years of 1885. It was the courthouse morning and the 4 pages from Judge Farwell and the precedent those pages had given to every small water user on the South Fork who came after her. The county record preserved the case. Other petitioners cited it. Farwell's ruling on the informal use standard was referenced in a State Water Commission report in 1899, attributed in that report to a 1886 petition argued by the South Fork landowner without counsel. The morning after Nora died, Clem's successor, a younger border collie named for no particular reason by Agnes, sat at the threshold of the open kitchen door, looking out at the yard and the creek beyond. The water was moving below the ice in the shallows, making the low sound it always made in the morning cold. The lamp on the kitchen table was still burning, the oil almost gone. The water went where it had always gone, and the law that said so was still on the shelf in the county record, written in a hand that had learned what it needed to know 1 page at a time.